Dear students, welcome back to your education channel Learn and Educate, where we were learning Code of Civil Procedure 1908, under which Section 148, Enlargement of Time, where any period is fixed or granted by the court for doing any act prescribed or allowed by this code. The court may, in its discretion, from time to time, enlarge such period prescribed or allowed by this code. The court may, in its discretion, from time to time, enlarge such period, not exceeding 30 days in total, even though the period originally fixed or granted may have expired. Thus, the court, at its discretion, may grant such enlargement of period which is not exceed 30 days in total, even though the period of originally fixed or granted by have expired. But the period of enlargement should be at the discretion of the court, but prescribed or allowed by the law under the Code of Civil Procedure 1908, where any such period granted is fixed by the court for doing any act has been expired, and the court at its discretion can allow enlargement of such time, but shall not exceed 30 days in total. Section 148A, right to lodge a caveat. Subsection 1, where any application is expected to be made or has been made in a suit or proceedings instituted or about to be filed in a court, any person who is claiming the right to appear before the court on hearing of such application may lodge a caveat in respect thereof. Thus, any person, an application is expected to be made wherein in a suit or proceeding filed or about to be filed in a court, any person who is claiming a right to appear before the court on the hearing of such application may lodge a caveat in respect thereof. Thus, caveat petition acts as a precautionary measure taken by the caveator against the expected applications to be filed by the opposite party. Subsection 2. Where a caveat has been lodged under subsection 1, the person by whom the caveat has been lodged hereinafter shall be called as the caveator, shall serve a notice of the caveat by the registered post, shall serve a notice of a caveat by the registered post. Thus, the caveat petition acts as a precautionary measure taken by the caveator against the expected application to be filed by the opposite party. Acknowledge shall serve a notice of the caveat by registered post, acknowledgement due on a person by whom the application has been, acknowledgement on the person by whom the application has been or expected to be made under subsection 1. Where after a caveat has been lodged under subsection 1, any application is filed in any suit, any application which is filed in any suit or proceedings at the court shall serve a notice of the application to the caveator. In any application under subsection 1 is filed in any suit or proceedings, then the court shall serve a notice of the of application to caveator. The court will serve a notice of application to the caveator. Subsection 4. Where a notice of any caveat has been served on the applicant, he shall forthwith furnish the caveator at the caveator expense. He shall, where any notice of caveat has been served on the applicant, he shall forthwith furnish the caveator at the caveator expense with a copy of the application made by him, and also the copies of any paper or any copies of document which has been or may be filed by him in support of the application. Subsection 5. Where a caveat has been lodged under subsection 1, a caveat which has been lodged under subsection 1, such caveat shall not remain in force after the expiry of 100 days. Such caveat shall not remain in any force after the expiry of the 90 days from the date on which it has lodged, unless the application referred to in subsection 1 has been made before expiry of such period. Thus, the caveat which has been lodged under subsection 1 of section 148A, such caveat shall remain in force. Shall not remain in force after the expiry of 90 days, which means that its period is 90 days only, unless the application referred to in subsection 1 has been made after the expiry of such period, unless an application under subsection 1 has been made after the expiry of such 90 days. Thus, a caveat is a notice to the register of titles and which, subject to some exceptions, has the effect of prohibiting the registration of land interest dealings unless expressly permitted by caveat, which is affecting the interest claimed by the caveator. The validity of a caveat is 90 days from the date of filing. One has the caveat petition correctly drafted and filed it in the court or retained the services to do the same. The notice of caveat along with the copy of the caveat petition. The notice of caveat along with the copy of the caveat petition to be sent to each person facing whom the caveat has been registered. The legal meaning of a caveat means let the person beware. The caveat is generally a Latin phrase which means a person. Let a person beware. In law, it is A formal notice where a person is always intimated before any legal actions which are taken against him or her. Thank you for watching.